Good Tuesday afternoon to you. Welcome to Court TV Live. I'm your midday host, Julie Grant. We begin this hour with our next big trial we're bringing you here on Court TV, and that is the case of defendants Gregory and Travis McMichael and William Roddie Bryan, who are accused over the death of Ahmaud Arbery, the jogger in southern Georgia who was shot to death in February of 2020. These are the three defendants, father and son there, and their neighbor. And we know that a flurry of pretrial motions have been filed in this case ahead of the jury selection, which is set to begin on Monday. Monday, October 18th is the day. And we've already got our crew in Brunswick, Georgia, standing by. Let's bring in Court TV legal correspondent Julia Janae to talk more about a major pretrial ruling about the jail phone calls that the state wants to introduce against these guys. Julia, good afternoon.
Good afternoon, Julie. We see jail calls come in during trial, but this was a really major part of the pretrial motions in this case. This defense did not want those jail calls, any of them, to come in before this court. They were already being used during bond hearings. And this judge has now ruled that that motion to exclude the jail calls is denied. And here's a look at some of his reasoning, especially when it comes to the argument that there was a Fourth Amendment protection or violation if these calls were allowed in. The judge said that the defendants received repeated warnings that the calls would be monitored and recorded, and they have a logically lowered expectation of privacy in prison, and the defendants consented to the detention center's policy by using that phone system. Accordingly, there is no reason to think that the phone calls could not be used at trial just like any other lawfully discovered evidence. There were also phone calls between Gregory McMichael and his wife, Lee McMichael, where they talked a little bit about the case. There was even a point where he asked her to tell their daughter to take down certain posts on Facebook, on social media, saying that that would really mess things up if she didn't take them down. So here's what the court said about the argument that there was a spousal privilege for that husband and wife communication. It said Gregory McMichael's decision to proceed with the conversations, despite the notification that the conversations were being recorded and were subject to monitoring, is no different from a defendant electing to proceed with conversations notwithstanding the known presence of a third party within earshot of a conversation with his wife. So the judge saying spousal privilege does not apply to jail calls, something we expected, Julie.
Right, Julia. I know we talked about this on the show many times, and the court certainly made the right ruling here. I mean, on those calls, you hear the notification right at the beginning that this is being recorded, which certainly eliminates that expectation of privacy when you're put on notice. And this is far different than pillow talk in a home between a husband and wife when there's notice that this is being recorded and monitored. So great ruling by the court. When we last talked, Julia, we were discussing a little bit of the state's strategy, what we think they might be wanting to introduce at trial and why in terms of the calls, because I know there are a lot of them. And there could be other objections, as you noted earlier, that the defense might be raising. But if you had to guess, what do you think we might be hearing at trial and why, please?
You know, there's 15 or 1,600 calls that jail officials said during a pretrial hearing exist. And the judge even talked about the fact that typically you go through each of these jail calls and figure out what you want, and then you bring it to the court. But there was this motion where the defense wanted all of them excluded just off jump, and that's something that the judge, of course, is denying. But I would think that of the phone calls that I've heard, one that may be key for the prosecution, especially in terms of Roddie Bryan, there's one where Gregory McMichael is saying that Roddie's an ally. Someone is asking him, who is that guy who shot the video? Who was the guy who was with you? And he assures them in a way that sounds like they were very familiar with him and that he is someone who was very helpful to them, that they can trust him. You know, or we can expect, rather, from what we've heard from the attorney for William Roddie Bryan, is that he's not connected that closely to the McMichaels, that he was someone who was just being a good Samaritan. They asked him to help him in this chase, and he joined in. But I think that could be a jail call that these prosecutors could use to show that there's a closer familiarity and support their idea that these three men were acting in concert together in carrying out this murder.
Oh, yeah, that's a really great point you just made, Julia, especially if we see William Roddie Bryan try to distance himself from the other two at trial. So excellent point you just made, where the state may try to link him with that. Now tell me, I know that the McMichael's defense team, again, has been pushing to try to get into this trial some details about Ahmaud Arbery. We talked a lot on Monday about how it may feel to Ahmaud Arbery's family that he is being put on trial, that his character is being attacked. And in this next push, the McMichael defense team, they're looking to get in THC levels in his blood to show that he may have been under the influence of marijuana at the time. And also the fact that he was on probation at the time. They want to get into court his probation status and go back to whatever case might have caused that. Talk to us about how the defense is arguing that this should come in, and where do things stand with the court at this time, Julia?
They are arguing that this is inextricably intertwined with the case itself. They feel that this would help a jury determine who was the primary aggressor, which is an important element in a self-defense case. Was Travis McMichael defending himself, or was Ahmaud Arbery trying to defend himself, being a subject or target of this chase? And this comes after the state put into a motion that they don't want any of those things, the probation status or THC levels, to come in. They say there is no proof that THC levels impaired or impacted any of the behavior that day. And they say it's irrelevant because, again, it's not something that the defendants knew at the time of this incident. But the defense says it is going to be key for helping them to show this jury what was happening that day. They say it's not about character evidence, but instead goes to their theory of the self-defense claim in this case. So the judge still has to rule on it. This came in a way where it's a state motion in limine asking the judge to clarify whether or not those two items fall under the character evidence that he already prohibited in this case. And the defense is saying, no, we think that the clarification should be this part should come in.
Wow. Julia Janae reporting live for us in Brunswick, Georgia. Thank you so much for all of that. Big decisions this trial judge has to make.